Good morning, section 11. How are you guys? Good to see you. Got a lot to do today, so let's get cracking. I hope you got my email. 2 o'clock today. I'm going to open up this classroom for you guys just to come and say hi, hang out, do whatever. I'll be around and with you for that. So hopefully I will not just be alone in the class, in the Zoom room, but I know that it's a busy time, so come if you can. Okay. So the goal today is, also, I hope that you, or maybe you have, there are additional conveyance problems, like another little worksheet up on Twin for you to review. That's primarily how we're going to be spending our time on Monday. Okay. So that is the administrative stuff. Anything else we will deal with as it comes up, but let's get back into this Spiller versus Macrith case. And I think we had gotten kind of the basics down. Did I leave y'all with a, I don't know, Kylie or Matthew or Scott, did I leave y'all with did I say what we were going to do when we started class?
You said we had one more thing to go over. We kind of left off talking about whether we thought the bar was too high set by the
Okay,
court.
so we got through most of it. We determined that the bar is pretty high, right? It's pretty high. There has to be an explicit demand and an explicit refusal in order to constitute ouster. The one extra thing that I think that this is what it is. So I think two extra things. Did we talk about constructive ouster?
I don't think we did.
Yeah. Okay. All right. So those of you who like a rule that is less high of a burden might like this idea of constructive ouster. And so with constructive ouster, the idea is that the co-tenant is using the property in a way that actually, as a sort of physical matter, prevents other co-tenants from also using the property. Okay. And so some people say that if there is such use, then there ought to be ouster. Like it should just be assumed that just because, like, it doesn't make sense to say demand and refusal. Rather, we should be able to just sort of look at the physical situation, and the physical situation is that this person is using it in a way that is exclusive and that is ousting the other co-tenants. And so that is the idea behind constructive ouster. And I'm here to tell you that constructive ouster is not a thing. Okay. It is conceptually, I think, very attractive. Okay. Why should Macrith have to go through the process of showing up and saying, I'd like to enter this warehouse, please let me do so, when a simple look at the warehouse indicates that there's nothing Macrith can do with the warehouse. If they can't fit, there's not enough square footage in order to make it so that Macrith can enjoy the property. The reason that there is no such thing as constructive ouster, even though I think there's a lot of sentiment for why there ought to be, is because, and I think we did talk about this, the Spillers of the world should be given the opportunity to hear a request, hey, I'd like to come in, and then decide what to do. That up until the moment of that request, they are not infringing on anyone's rights. They are doing exactly what they're entitled to do, which is enjoy to the fullest every square inch of the property. And then once they are told, hey, I'd like to use the property too, then they should be given the opportunity to allow that to happen. And therefore everybody, is happy, or deny it and have to pay the rent like in an ouster. And so most jurisdictions follow the rule that is there has to be an explicit demand, an explicit refusal, and constructive ouster, not a thing. But I just wanted to put that out there that constructive ouster is often talked about and is very attractive to many people, but not an option. Okay. The one thing that I did want to cover back here is, and Matthew, I'll ask you this. Ouster triggers rent. Okay, so ouster triggers rent. If Macrith shows up and says, hey, I'd like to use this warehouse, and Spiller says, get out of here, Macrith, it's all mine, then that ouster has occurred, and Spiller, in theory, owes Macrith rent for that. What is another effect of Spiller doing that of ousting a co-tenant?
He gets, what's his name again? Macrith gets the rent money, but he still doesn't have his property rights.
Okay. So let's say that there's no rent involved, right? So that instead of, hey, let me in, no, get out of here, okay, I'm going to sue you for rent and win, right? Instead, it's just, hey, let me in, no, get out of here. And Macrith leaves. Okay. Which hopefully we're all on the same page. Spiller can't do that, right? That's a violation of Macrith's rights. Spiller cannot legally do that. But we've seen other situations in which people do things that they can't do, and it grows into a property right. So what might be happening in this circumstance?
I guess you could say like adverse possession over, I guess, the entire rights of the property. Like he's not sharing it anymore is what's happening. Like that clock would start, you could say.
Exactly. So ouster triggers rent, but ouster also, or liability for rent. Ouster also triggers the statute of limitations for adverse possession. It is very difficult for co-tenants to adversely possess against one another. Okay, primarily because of permission, right? Spiller has the right to be on the full property. And so it's hard to say that Spiller is hostile when Spiller is just doing what they're already entitled to do. However, if what happens is Macrith shows up and says, hey, let me on, and Spiller says, get out of here, at that point, Spiller is denying co-tenancy, is excluding Macrith from the property, has done so in an open way. They are actually violating the sticks that Macrith ought to have. Okay, and if that continues for a long enough period of time, continuously, etc., then we could have, in very rare circumstances, adverse possession among co-tenants. But I just want to make the point that ouster is the linchpin to that potential adverse possession, just like it's the linchpin for rent between co-tenants. Okay? Does that make sense, folks? We good? Questions? Yeah, Annie?
Okay, so if Macrith shows up saying that he would like to use the warehouse and Spiller says no, how does that trigger the statute of limitations for adverse possession? Because that would be Macrith trying to like assert their ownership rights.
Yeah. So if they do nothing from that moment forward for 7 years or 10 years or whatever it is, then it's over.
Okay,
right?
so it's assuming they do nothing forward from that point. Okay.
Correct. It begins at that point, right? In what Macrith ought to do at that point is sue for rent. And if they sue for rent, then we don't have an adverse possession problem because that's Macrith asserting that they have been denied, they're not sleeping on their rights. Others on Spiller and Macrith? We good? All right. Let's push on through with Schwartzbaugh and Sampson. This one's fun. Okay. So let's begin with Mega. There you are. So let's just give me a little bit of the backstory here. How did the Schwartzbaugh and Sampson conflict come to be?
So basically, the defendant is Mr. Schwartzbaugh and the plaintiff, and which is Mrs. Schwartzbaugh, and they're married and they own 60 acres of land as joint tenants. And so the defendant, which is Sampson, negotiated with the Schwartzbaughs to lease a portion of the land for a boxing pavilion, and Mrs. Schwartzbaugh objected to the lease, and Sampson knew that she wouldn't agree. So then Mr. Schwartzbaugh and Sampson signed a lease, and Sampson proceeded to take exclusive possession of the leased property by creating and operating a boxing pavilion. And then Mrs. Schwartzbaugh initiated this action to cancel the lease.
Great.
And then the trial court granted a
Well,
non-suit.
hold off. So she wants to cancel the lease. We'll pause there.
Yes.
First of all, did I pronounce your name correctly?
Yes, sir.
Okay. Second, something that Mega said was that they're married. I just want to note for everybody, the fact that they're married makes this very soap opera-y, but it's actually not relevant to this case. Okay. The fact that they are married makes it interesting. Like, why are they in a lawsuit with each other when they're still married to one another? And that's fun, but it's not relevant. It could be any two joint tenants here, right? It's a detail that's important for us to maybe keep in mind. Remember this case, but it doesn't have any sort of legal effect. The reason I mention that is because I think I told y'all about the other kind of concurrent estate, the tenancy by the entirety, in which it's held by a married couple. If this had been tenancy by the entirety, then it would matter, obviously, that they're married, that there's different rules that would apply. But this isn't that. This is just a joint tenancy held by two individuals who happen to be married to one another. And, I just want y'all to be straight that the fact of their marriage is interesting, but not really that legally important. Okay, so Mega has given us a good sort of timeline of the way that this unfolds. And so you mentioned, Mega, that Sampson knew that Mrs. Schwartzbaugh did not want this boxing pavilion on this property. Okay. Why does that matter?
Because
that does matter.
Because she holds half of it. Like she's
Okay, so
technically she holds all of it because she's in joint tenancy with her husband.
Mhm.
And so in order for Sampson to use that property, he would have to have permission from both parties since they both have possession of it.
Maybe. Let's back up. What does Mr. Schwartzbaugh have? Let's list his interests. He has what?
Fee simple.
A half fee simple as a joint tenant. Good.
Yes.
And so what comes along with that?
He has like full ownership of the land.
Okay. So what does that mean? What can you do with full ownership of the land?
Well, he can lease out the land. He can sell the land.
Mhm. Could
He
put a
can
boxing
enjoy the
pavilion?
land.
Yep. Could he put a
Yes.
boxing pavilion on the land?
Yes.
Yes. Use the land. Could he exclude people from the land?
Yes.
Everyone except who?
The co-tenant, which is his wife.
Exactly. Can exclude everyone from the property except for the co-tenant. And what else comes with a joint tenancy that's extra special? What happens if she dies first?
Oh, then he gets full ownership of the land.
Yep.
He gets
so
full fee simple.
Exactly. So we've got a right of survivorship here as well. Okay. So we've said fee simple interest, 1/2 in joint tenancy. We said the right to use, right to joint full enjoyment, right to full enjoy, the right to exclude everyone in the world except for the co-tenant, and the right of survivorship, in addition to the other sort of sticks that go along with fee simple, the right to lease it, the right to sell it, the right to give it away, etc. Okay. What about Mrs. Schwartzball? What sticks does she have?
She has all of those that Mr. Schwartzborough has.
All exactly the same, right? So they have the same bundle. And so I asked you for a second ago, could he build a boxing pavilion on this property? And you said,
Yes.
could she stop him if she didn't want a boxing pavilion, but her co-tenant did?
Yes.
How?
By not signing the, I guess, building permit. I don't know.
So I guess where's the building permit coming in? Who's seeking the building permit?
Mr. Schwartzborough?
And he's getting it like from the city or something like that?
Yes. Well, I don't know, since it's their property. I guess they would have, I don't know.
So it sounds like what you would like for there to be happening here is that the joint tenants agree before anything happens on the property.
Right, because they have to agree before anything is built since they both own it.
But do they? Is that how joint tenancy works? It should, right? What you're describing is a nice world in which joint tenants would come to an agreement and say, okay, do you want a boxing pavilion, honey? No, I don't want a boxing pavilion, honey. Okay, well, let's come to something that we can both agree on and use our property in that way. Okay, and that would be nice. But my question is that required? Does Mr. Schwartzball have to get her permission before he starts building a boxing pavilion? And let's say he's just going to do it with his own bare hands. So we're not going to involve the city or anybody else. He's just going to build the boxing pavilion.
Well, technically, he wouldn't need permission since it is his property and he holds it in fee simple.
If she wanted to build a boxing pavilion, could she do it?
Yes.
Yes. Okay. So joint full enjoyment means I don't have to get permission from my co-tenants to do whatever I want on the property. Did Spiller have to get permission to move the boxes into the warehouse?
No.
No. Okay. So it would be great if co-tenancy worked in such a way that they had to actually get permission from each other in order to do anything. And in fact, side note, you can forget it as soon as I say it. In a tenancy by the entirety, you do. Okay. In a tenancy by the entirety, you do. That's why I made that point that it would make a difference if this was a tenancy by the entirety, but it's not. It's just a regular joint tenancy. Okay. And so you don't have to get permission to do what you want to do on the property. And so I'm going to ask same question I've already asked Mega. Could she stop him?
No.
No. Generally, no, right? There are ways in which she might be able to stop him, on a waste theory or something like that. But as a sort of basic principle, he can do it without her permission, and she can do it, and she can't stop him. Just like if she wanted to build, a walnut tree adventure without his permission. What would a walnut tree adventure be? I don't know. If she wanted to build that without his permission, she could do it and he couldn't stop her. But there's a conflict, right? There's a conflict with those two principles that how can it be that they, if they don't want to do the same thing with the property, we might have a problem. So we'll come back to that. So Alex Gilbert.
Yes.
Mega has told us that Mrs. Schwartzball wants to cancel the lease. Okay.
Mhm.
So what does she believe? If she is saying, hey, cancel this lease, what does she believe that the lease is for?
Let's see. If she's saying that that she wants to cancel the lease, the lease is. Can I call in co-counsel?
Well, let me ask you this. If I, let's say, if I lease property to you,
Right.
could Mega sue to cancel the lease?
No,
Why?
because the lease isn't for her. The
It
lease is
has
for
nothing. It has
has
nothing
nothing
to do with her, right?
Right.
It's my sticks are being leased to her. I mean, to you, sorry, and
Right.
her involvement, like she's just a random person I just threw into the hypo. She has nothing to do with our relationship,
right.
right? So, but if let's say Mega owns some property and I came to you with a lease that purported to be a rental of her property to you, could she cancel that lease?
Yeah, because it's her property.
Exactly, right? Like if I'm binding her rights, then it seems like she ought to be able to cancel that or at least get
Yeah.
involved with it. But if I'm not binding her rights, then she's just a random third party to the relationship between a landlord and a tenant.
Yes.
So, okay, so all that, I think we're straight. What about this lease from the Schwartzball property to Sampson? If she is suing for cancellation of it, what must she think is included in that lease?
Some of her property rights.
Some of her interests. Good.
Right.
So is it?
No.
Is that what you think, or is that what the court says? Or both?
Both.
Both. Okay. So how could that be? How could it be that her interests are not affected by this lease?
Let's see.
So Sampson is saying, so she's saying, hey, you've bound my rights, right? And she's relying on this idea that you can't give away my rights, just like Mega would have been interfering and saying, hey, Professor Keel, what are you doing leasing out my property to Alex? You can't do that. That's
Right.
what she's saying. But Sampson and Mr. Schwartzbar are saying, no. What we had between us was not involving your rights at all. So how could that be?
I'm just having trouble articulating exactly what the rationale behind it is, but basically what they're saying is that is that the property, like that she has no property right interests in the property, and no.
Well, I mean, we know she's a joint tenant, right?
Yeah.
Mega articulated a whole bunch of things that she does have rights. So
Right.
we're really worried about this lease. The lease is only of what?
Oh yeah, the lease is only of the lease doesn't affect her joint tenancy. It only affects the it's basically she could still be joint tenants with the person that the other part of the property is leased to.
Exactly. So if Mr. Schwartzbaugh and Sampson were describing what was included in the lease, right? Her theory was my rights were included in that lease. But if they're responding and saying no, what was included in that lease?
Only their rights to the property were included in the lease.
Only Mr. Schwartzbaugh's rights were included.
Right.
Okay? So only Mr. Schwartzbaugh's rights were included. And so as you said, I think this is right, as you, it's just like now she's a joint tenant with Sampson, at least for this portion of the property, instead of Mr. Schwartzbaugh, that he's stepping into Mr. Schwartzbaugh's shoes.
Yeah.
Okay. And so that theory is the one that Sampson is putting forth. Audrey, is that like, does that sound right to you? Like that this lease is only of Mr. Schwartzbaugh's stuff?
I think it sounds right, but I could see, I mean, Mrs. Schwartzbaugh doesn't understand joint tenancy, so it's
Okay.
not gonna click with her, but I think it's pretty clear that he, as the sole signer or as the sole leaser of it, is only conveying his interest.
Okay. And from if I were to sort of force you to step back, can he convey anything but his interest
No,
unilaterally?
half of fee simple.
Say again?
He only has half fee simple, which does give him like joint full enjoyment.
Mm-hmm.
So I mean, yeah, I would say he only has that half to give away, which sounds contradictory to the full enjoyment of the property. But I guess as far as leases go, that's the extent to which he could exercise.
Mega gave us a great list of the interests that Mr. Schwartzbaugh had, and they included the 1/2 fee simple and the right to full enjoyment. And one of our big principles in this course is any right that you have, you can do stuff with, right? And Mr. Schwartzbaugh has a 1/2 fee simple and the right to full enjoyment. And so he can convey any rights that he has. Can he convey rights that he doesn't have?
No.
No, right? We can do whatever we want with the rights that we have, and we can't do anything with the rights that we don't have. And so the Sampson and Mr. Schwartzbaugh response to Mrs. Schwartzbaugh is to say, I'm sorry. I would have liked to have leased your portion of the property, but I cannot do that, right? I am precluded from doing that. So what is Sampson paying for?
He's only paying for the half he has plus all the expenses for his boxing pavilion.
Right, the half interest,
Right.
right? But the full enjoyment, he's paying for Mr. Schwartzbaugh's rights. Can he exclude, if she shows up, if Mrs. Schwartzbaugh shows up and says, hey, I've had a change of heart, I want to come to the boxing match, could he exclude her?
I think no, because she has full enjoyment.
Not on their theory, right? On their theory, she has full enjoyment, and so she could not be excluded. Exactly. Okay. And so I'm hoping everybody's following this, that Mr. Schwartzbaugh and Sampson's theory is that all that's happened here is that Sampson is subbed in for Mr. Schwartzbaugh. And just like she couldn't stop Mr. Schwartzbaugh from building a boxing pavilion, she can't stop Sampson from building a boxing pavilion. And the flip side of it is, just like Mr. Schwartzbaugh couldn't exclude her from the property, neither can Sampson exclude her from the property. Okay?
Can I ask a question?
Yeah.
So the walnut trees, does his like cutting those down for the construction of the pavilion, like, does that just not matter because he has full enjoyment, even though that hinders kind of her full enjoyment? Like, what's going on there?
So it starts to become tricky when you have, so if this were a waste, like life estate and future interest kind of situation, I think it would be a little easier, because then we would say that the cutting of the trees interferes with the expectations of the future interest holder, et cetera, and we could call it waste, or at least we could do that analysis. But in this instance, what one co-tenant wants to do requires the cutting down of trees, and what the other co-tenant wants to do precludes the cutting down of trees, and so it's irreconcilable. And so, this is fast forwarding a little bit, but let's say she straps herself to one of those trees and says, you'll cut these trees down over my dead body. Okay. what has she done? If she, and then Samson's like, I'm out of here. You know, I don't want any part of that. What has she done?
Is that like a manipulative form of ousting?
I think so,
Okay.
right? So explain why.
She's excluded him from something he has the interest and right to
Exactly.
by doing so, yeah.
Exactly. We might need, some more facts about, is there an explicit demand? Hey, I'd like to cut down the trees. And she says, no, get out of here. You can't cut down the trees. An explicit demand, an explicit denial or refusal. And then we have ouster. Okay. So I think that is, we're going to talk about what the options are after this case, what she could do. But that's one of the options that she has, is to take ownership and oust him. But I guess I'll go ahead and ask you, Audrey, if she does that, then what happens?
If she ousts,
Mm-hmm.
she owes him rent for his
Owes
interest.
him rent.
Yeah.
Good. Good. So everybody see that? Just like in Spiller versus Mackreth, if there had been an ouster, then the occupying co-tenant, the ousting co-tenant, would owe rent to the ousted co-tenant. Here, Mrs. Schwartzbaugh, in this example, would owe rent to Samson, right? Who is the ousted co-tenant, at least temporarily, under the terms of the lease. Okay? All right. So, and Audrey, the outcome here is
Is
Yeah, go.
Mr. Schwartzbaugh and Samson's stands.
right. And so she cannot cancel this lease.
Right.
Lauren, do you think that's the right outcome here?
I think so, because with the so you're saying that the lease was valid and whether that's the right choice. Is that what you're saying, or essentially? Okay. Yeah, I think that was the right choice, because with the joint tenancy, it talked about how she doesn't have the power to basically can't, like, the other joint tenant doesn't have the power to cancel that lease that the other co-tenant had signed. They just
Right.
gave them exclusive to that property.
Yeah, there's sort of two sides of it, right? On one hand, he, Mr. Schwartzbaugh, could not bind her interests in the lease. Okay. And then looking at it from the other side, she cannot interfere with what he's done with his interests, right? And he has leased them out. So he could not have leased her portion out. And she, since he's leased his, can't interfere with that lease. Okay. So in her recitation of sort of how we got to this point, Mega mentioned that Samson knew that that Mrs. Schwartzbaugh was not in on this. And I asked her, why does that matter? Or does that matter? So now I put the same question to you. Does it matter
I would say
that he didn't know?
it doesn't matter at this point,
Why?
because since that wasn't her portion of the property to lease.
So you're saying Mr. Schwartzbaugh could never have bound her sticks.
Yes.
Okay. So let's back up a little bit. Let's say that, I don't know if they give us the dollar amount in here, but I'm just going to assert that it was $1,000. Okay. And I want to imagine two different worlds. In world one, it's the world of the case. Okay. Where they try to get Mrs. Schwartzbaugh in, and Mrs. Schwartzbaugh is like, no, 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 no. And they proceed anyway, right? They proceed anyway. So that's world one. And they, in that world, agree on $1,000 per month for Samson to pay Mr. Schwartzbaugh to lease the property. Okay. Now let's imagine world number two. And in world number two, Mr. Schwartzbaugh shows up and says, hey, I'd like to lease this property to you. I hold it with my wife. She's upstairs. And we'd like to sign this lease for $1,000. How about $1,000 per month? And so they agree. And so my question is, what's different about those two circumstances?
So you're saying what the only difference was whether the wife agreed or not in the second scenario?
It's not, in the second scenario, it's not clear that she agreed, but from Sampson's perspective, it may appear that she agreed.
There was no obvious disagreement from her,
Correct.
even though like, it seemed like it was assumed.
So should that matter?
It in the ruling of the case, it shouldn't, but essentially,
If you were
well,
Sampson,
yes, it should, but in the
if you were Sampson, would it matter?
if you're, yeah, I think it would because you'd be a lot more comfortable using a property if it was agreed upon by both joint tenants,
Heck yeah,
or
right?
especially building.
Yeah. If you're going to spend $1,000 and you think you're getting everybody's interests, well, that's one thing. But if you are in a different situation and you spend $1,000 and you know you're not getting everybody's interest, that's a different thing, right? So
Yes.
my question is ultimately, does the fact, and I think that the answer is yes, so I'm going to give you the answer and have you tell me why. Does the fact that he knew that it was only her interest actually end up helping their case that the lease was only her interest? Right? Their position is that she can't cancel the lease because she's not a party and her rights aren't bound by the lease. And I'm wondering, is that made easier to get to that conclusion because he knew, Mr. Sampson knew that she was not in on this?
Yeah, because then you could make it look like it's a lot more separate rather than just one property bound together between the two, and that makes it clear that both parties have separate rights rather than it having to be, consenting between Mr. and Mrs. Schwartzbaugh.
Exactly. So in the sort of alternative universe, Mr. Sampson, or I keep calling it Sampson, might have expected that he actually was getting her interest. Okay? Because there's no obvious reason for disagreement, and it's maybe the representation that Mr. Schwartzbaugh is making implies that she's okay with it, even though she isn't, right? And so I just want y'all to hear that, we have the idea of a good faith purchaser, where someone who makes a purchase that actually isn't right? Like there's something funky with it, but they don't have notice that there's something wrong with that. Okay, and they pay full value. When that happens, we sometimes preference a good faith purchaser over even the true owner. If Sampson didn't know that her rights were bound, right? Or that weren't bound. If he didn't know, then he might qualify as what we might call a good faith lessee, right? A person who is leasing property, leasing interests that the lessor didn't actually have the ability to lease, right? I think we're straight. Hopefully everybody's with it, that Mr. Schwartzbaugh could not lease out her interests, okay? But this is a slight exception. If he purported to, if he represented that that's what he was doing, and if Sampson was paying value for the full interests, well, then maybe it would be found that he did have the right, Sampson did have the right to exclude Mrs. Schwartzbaugh. Okay? So I do think it matters in this case that Sampson knew, and I think it makes it much easier to get to the outcome that they get to, that these interests were separate, that Sampson was fully aware that they were only getting a half, and Therefore, we move, she's got her sticks still, and Sampson's now got Mr. Schwartzbaugh's sticks. Okay. So, Lauren, what I'm going to ask next, I see a question here from Peyton. But what I'm going to ask next what should she do now, right? She's lost this case, Mrs. Schwartzbaugh has. What ought she do now that she's lost? While you're thinking about that, Peyton, what's your question?
You said it was possible for the court to come to the conclusion that Sampson had the right to exclude Mrs. Schwartzbaugh if he thought he was getting rights to the whole property. If the court
Yes.
came to that conclusion, would they say she gets this portion of the rent that he's paying,
Yes.
or tell Mr. Schwartzbaugh to pay her something else entirely?
She would be entitled to a portion of the rent, just like you said.
Would you call that ouster?
In a way, you would call it ouster by Mr. Schwartzbaugh, not by Sampson. It would be as though he ousted her by selling her shares, right? Selling her sticks, or leasing at least her sticks. So I don't know that you would call it ouster, but conceptually it'd be the same effect. A denial of co-tenancy. All right, so Lauren, you got any ideas? You're advising Mrs. Schwartzbaugh now. She's lost this case. She really doesn't want the boxing pavilion. I've already spoken with Audrey about one thing that she could do. She could oust. What else might she be able to do?
There were a couple options on page 380. One of the ones was she could partition for the fraction leased for the duration of the 5-year term.
So what's the upside of that?
So the court could order, I could be wrong, but the court could order the sale of the land back to Mrs. Schwartzbaugh.
Okay, so she could purchase it in a partition sale. What would be the downside of a partition?
It could be the partition could fail and the Mr. Sampson could hold on to it, or she would have to purchase it back.
Okay, so she might lose. She might lose in the partition sale. What if it's a partition in kind? What's the downside there?
A partition in kind. Would that mean she's not getting all of it back, or it'd just be? I might be missing something on that.
Mega, can you identify a downside to the partition in kind for her? So I think Lauren is right. One thing that she could do is sue for partition, and just get, in this co-tenancy. What would be the downside of a partition in kind, Mega?
So if it's a partition in kind, then the property would be divided, and then she probably wouldn't have control over which property she would want.
So she might be able to protect some of the trees, but what would happen to the part that she did not get in the
She would
partition?
lose that.
She would lose that. So she would go from a situation in which she would, I guess it's upside and downside. She could protect some trees, but other trees she would have actually no interest in whatsoever. She would be completely separated out. Okay. So partition is an option. Oust, which is what I discussed with Audrey earlier, is an option, but ousting would lead to her owing rent, right? Having to pay rent to Sampson. Mega, do you have any other ideas of what she could do?
I just had partition and oust.
Think cooperatively. Right? We're in law school, so we just automatically think we're going to sue. But what could she do?
I mean, she could live with it, but
Okay. But then that doesn't help that doesn't help our walnut trees.
right.
Alex, you got any ideas?
Me or another
Yes.
Alex?
Nope. You, Alex.
No.
Okay. Lauren, I saw your hand. Yeah.
I was gonna say she could sue her husband to get a portion of the rent money from Mr. Sampson.
Okay. She could. Is she going to win that though?
Probably not.
Yeah. So why isn't she? Why is that likely to be unsuccessful?
Because it's his portion of the joint tenancy, not hers.
Yeah. The $1,000 is only about his sticks. And so normally you would say, we're going to talk in just a second about rents. Normally when rent is being received for co-owned property, the rent has to be split. But in this kind of weird circumstance where it's clear that he is only paying for Mr. Schwartzbaugh's sticks, I don't think it would be appropriate to have that $1,000 split, right? I think that $1,000 is just for Mr. Schwartzbaugh's sticks. Audrey, we talked about how she could oust him. What else might occur here? It might not save the trees, but it could at least get her some money.
I don't know if this is like the right definite answer, but on 380, on note number 3, well, it's not note number 3, but it says postscript, and it's basically talking about her cooperation after Mr. Schwartzbaugh died. And I'm pretty sure she was able to gather rent from him with her daughter following the death, right?
Okay. So this is not what I was pushing towards, but this is the cooperative response,
Right.
right? The cooperative response is, let's work something out, right? Let's come to some sort of agreement where we can preserve some walnut trees and I can live with the box. You know, I've lost this case, so I've kind of lost my, if I'm Mrs. Schwartzbaugh, I've lost the case, so I've kind of lost some of my negotiating power, but I still could come to some sort of agreement because I could still make your life miserable here, right? Like I have joint full enjoyment. So I lost, but I didn't lose my right to joint full enjoyment. So if you want me to not make your life miserable, let's come to an agreement. And it seems like maybe over time, that's where this ended up. So the reason I was joking, like we're in law school and we just want to sue. Sometimes people, especially first-year law students, overlook that, like, hey, you can come to an agreement that doesn't involve suing each other. And so I just encourage you guys to keep that in mind when you're asked to list sort of options. It's always a good thought to say, well, can we come to some sort of agreement for how this is going to be dealt with? Mega, I saw your hand up. I didn't know if you had a different one or was that the one that you wanted to raise?
I was gonna say if they could come to an agreement to where she would have some sort of access to the walnut trees. But yeah, pretty much same thing.
Yeah, exactly. So that's a good option. That's maybe a happy option here. But Audrey said that she could oust him, right? She might have to pay, but she could oust him. What else? Anybody else have any ideas of what she could do? Right? We imagine this conflict between them. Yeah, Mega?
Well, in terms of ousting, could she get herself oust?
Yeah. So how would she do that?
She would, I guess she would basically, trying to think, she would have to ask maybe for access. And then like, I guess if he ended up saying no, like you can't, then it would, I don't know, it would get denied and then
That's it.
she
right?
could ask. Yeah.
And then what could she get? She at that point she's been ousted. So the walnut trees maybe aren't able to be saved, but
She can get rent.
she can get rent. And would that rent be on top of the $1,000 that he's already paying to Mr. Schwartzbaugh?
Yes, because what he's paying is for Mr. Schwartzbaugh's interests and his I guess, his property rights and stuff, but he's not paying her out of that. So that would be on
Not
top of
yet.
it.
Exactly. So Lauren said maybe he could sue, excuse me, maybe she could sue for a portion of the 1,000, and we decided that that actually would be unsuccessful. But if she were to get herself ousted, then she could charge him rent on top of the 1,000. So 1,000 would be going to Mr. Schwartzball, and some amount would be going to Mrs. Schwartzball, and presumably it'd be at least 1,000 to her because she had the same interests that Mr. Schwartzball had. And if Mr. Schwartzball's interests were worth 1,000, then presumably hers would also be worth 1,000. And in fact, they may be worth more than 1,000. The fact that he's already paying to Mr. Schwartzball isn't really relevant. At that point, he is now excluding her and would have to pay the fair market value of her interests, whatever that ends up being. Okay. So she could both oust him and owe rent, or somehow figure out a way to get herself ousted, right? We have to kind of be creative for how she's going to accomplish that, because she can't control how he's going to respond. I like to imagine sometimes like she shows up at the boxing match with like a boxing is murder or some sort of protest in which is driving away customers from the boxing match. And he doesn't like, that's bad for him. So he's like, get out of here. And as soon as he says that, then she's ousted, then she can collect rent. Of course, all of that could be avoided if we could just come to some sort of agreement, which is, I think, an option as well. Yeah, Jack.
Can two joint tenants, can they lease the same space to different tenants? Like, could she lease that space to somebody else that would?
Yeah.
Okay.
So when I said, I think maybe it was in response to Audrey, she could make his life miserable. That's one way she could do it, right? She could, oh, you leased your portion to a boxing pavilion builder. I'll lease my portion to to a garbage dump, right? And let's see how you like that. And you can't stop me any more than I can. So you can see, like, obviously, and again, the fact that they're married just makes this all the more interesting. But it could happen in any co-tenancy, this kind of dispute. But the answer to the question, Jack, it should make sense to y'all. If he can lease his out, then she can lease hers out. If they have joint full enjoyment, even though they disagree, that's just the same as if two lessees have joint full enjoyment and don't want to be doing the same thing. Obviously, this is a recipe for a partition or some sort of end of this co-tenancy, if it comes to that. Questions on Schwartzball? It's a case that at first doesn't make a lot of sense because of the way that the court articulates that lease. But once you back out of it and you say, okay, well, what they were leasing was explicitly just Mr. Schwartzball's share, then it kind of does make sense that she couldn't cancel the lease. Okay, so I want to walk through one last bit of stuff, and then we'll be done. We'll be done. Like, that'll be that. Everything we got to cover. So let's do that. So I'm going to share my screen in just a sec. And we're going to walk through how concurrent estate holders deal with the benefits and the costs of co-ownership. Okay, both the benefits and the costs of co-ownership, because property ownership comes with potential benefits, but it also comes with potential costs. And when the property is held by co-owners, it starts to become complicated how those costs or benefits are shared. So before we go further, I want to make something absolutely clear, and it builds on what part, at least, of the way we finished up the Schwartz-Ball discussion. And that is that what we are about to go through are default rules. That means they are rules that will be the answer to problems only in the event that the parties haven't otherwise come to some sort of agreement. The vast majority of concurrent estates have some sort of agreement about how these kinds of things will be worked out. Okay, but not all do, and not every potential benefit or cost is accounted for in every agreement. And so what we are covering now are the default rules that apply in the absence of agreement. Okay, so here's our situation. A, B, and C hold in tenancy in common with equal shares. B and C live out of town, and A is in town. And so A is doing what B and C want to happen here, what all three of them want to happen here, which is rent out the property. Okay, so A is found a tenant to move in, and they lease the property, and they pay $3,000 a month in rent, and they pay that directly to A. So A personally is taking in $3,000 per month, even though A's interest is only 1/3 of the fee simple. Okay, so that's one type of situation. Very similar type of situation. Instead of renting it out, let's say A knows that there is oil under the property, or in the ground or whatever, and they issue a license to the oil company to come in and drill, and they do so, and the oil company pays this licensing fee to A directly. Same idea. They don't even know that B and C exist. It's just they've always dealt with A, so they make their payments to A. And so hopefully you guys are recognizing that B and C probably ought to be entitled to a portion of those benefits, right? The rent that that A is receiving in the first example, or the licensing fees that A is receiving in the second example. And so what if they don't already have an agreement, A, B, and C, then can B and C get that? Yes, they can. They can through what's called an accounting action, which we kind of talked about a little bit in the Schwartz-Ball context. So an accounting action is an action brought by a co-tenant to receive their appropriate proportional share of rent or profits from the land. Okay, so an action brought by a co-tenant to receive their appropriate proportional share of rent or profits from the land. Okay, so B and C could bring an accounting action and get their 1,000 each in these examples. Now, profits from the land with oil is easy, right? A is not doing anything here except finding the oil company and licensing the property out to them to do their drilling. If, let's say, a different circumstance, A is just living on the property and running their business out of their house, okay, and making a lot of profits, those profits would not be profits from the land, even though A is on the land and making the money while they're on the land. The profits are not from the land. Okay, so let's say they're running some sort of web design business or something like that. That is not profit from the land that B and C can get at. Oil, easy in the other direction, clearly from the land. Rent, clearly from the land. Okay, and so yes, accounting. In the other class, they asked about farming. Farming is a tough sort of in-between topic here, where at least some of the profit is from the land, from the soil, the crops, but some of the value from farming is from the labor of, let's say, A in this example. So we're not going to have to do this, but what happens in a case like that is you have to disentangle what portion of the profit is a result of A's labor, and that is kept by A, like the web design. And what portion of the profit is a result of the land. And that portion is subject to an accounting action. Okay, so it's often difficult to disentangle, and I don't want us to worry too much about how you would do that. I just want you to sort of be aware that sometimes that has to happen within an accounting action, that you have to separate out profits from the land from profits from labor. Okay. So I'm going to pause here. Questions on accounting actions? Okay. It's not all benefits. Sometimes it's costs involved in property ownership, like taxes or like paying off your mortgage. So let's say we have the same basic setup, and instead of A getting all the money, let's say A is paying all the money. So A is paying all of the annual property taxes, or A is paying each month's mortgage payment on the property. So the question there is not, can B and C get their share of the benefits, but can A force B and C to pay their share of the costs? Okay. And the answer, just as with the first example, is that yes, A can, and the type of suit that they bring is not an accounting action. It's called a right of contribution. So they bring a case for a right to contribution for their appropriate, to be reimbursed for the appropriate costs that should have been borne by other co-tenants. Okay. That's universally the case for taxes. And this is even where A is the one that's living in the property, or the exclusive co-tenant in possession. And it's because if you fail to pay the taxes or you fail to pay the mortgage, the property gets foreclosed upon and everybody loses. And since everybody loses, everybody should have to contribute to things like taxes and mortgage payments. That being said, there is a slight exception here that some jurisdictions, and I hate this exception because I don't think it logically makes any sense at all, but in some jurisdictions, a co-tenant in possession, in exclusive possession, so like if A is the only one living on the property and only one using it, they may not be able to get the right of contribution for mortgage payments. Okay? They still can for taxes, but not for mortgage payments. So again, I don't understand why they should be able to, or why they shouldn't be able to at all. And I don't understand why it would be different for taxes and mortgage payments. I'm just reporting out that in some jurisdictions, this exception exists. Okay. And just a quick reminder, all of this only applies if they don't already have an agreement. If they agree and B and C say, hey, here's the deal. You live on the property, you pay the taxes. And A says, great, then guess what happens? A pays all the taxes and cannot bring a right of contribution. Or alternatively, let's say B and C say, look, we want to lease it out too, but we don't want to do any of the work. So how about you find us someone to lease it to, and you keep half and we'll split the other half. So instead of a third, A takes half sort of as essentially like a fee for doing the work, and B and C take a quarter each. If that's what they agree, there's no accounting action that B and C could bring to get their share up to a third. Okay? We all right with right of contribution? All right. Other costs, repairs. Oh no, the roof breaks. A spends $3,000 fixing the roof. Question is, can A sue to force B and C to pay their share of this repair? Everyone's, at least, everyone's ownership interest is the same. Now A has undertaken the entirety of the cost of a repair. And the question is, just like they could get reimbursed for overpayment of taxes or mortgage payments, can they also be reimbursed for overpayment for repairs? The answer here is different. The answer here is no. During co-tenancy, A has no right, has no cause of action to get paid back for costs incurred during repair. Okay? Cannot do it during co-tenancy. However, they're not totally out of luck. If there is a partition, then the co-tenant who has overpaid for a repair receives what's known as credit upon partition in the amount of their overpayment. So here, it's an overpayment by $2,000 for A, right? This $3,000 benefits all three of them and therefore should be split three ways, $1,000, $1,000, $1,000. So A should have spent $1,000 on the repair, but instead spent $3,000. So their overpayment is $2,000. So what happens is, upon partition, let's say the partition sale happens and it's a $77,000 sale. Before that $77,000 is split, A is given the $2,000 overpayment first. And then the remaining part, don't want to cause panic when I say remainder, the remaining part is split three ways. So here, $27,000 to A, $25,000 to B, and C is how that $77,000 will be split. Okay? It is possible that it's a partition in kind. In that instance, A will either get a slightly larger share, or I think more likely, the court will then at partition force B and C to pay the $1,000 that they ought to have paid to A for the repair. So they'll split it still in thirds if it's a partition in kind, and use OLT as a way of accounting for the overpayment that A has made for the repair. Okay. Questions on repairs. You might be wondering two questions, which are really hard. When is a repair necessary? And what if A has, spent more than they needed to on the fix? So, let's say the roof was kind of old, but it hadn't yet broken. Is that a necessary repair, or is that something that A kind of did without it being totally necessary? Or alternatively, the roof did break and there was a $2,000 roof available, but A decided they wanted the nice one, and so they went with the $3,000 roof. Okay, so we're not going to answer those questions. I want you to be aware that there is often ambiguity and litigation about A, whether a repair is necessary, and B, whether the repair that was undertaken was at a reasonable cost. Okay, and precisely because those are difficult questions, that's why that only once the co-tenancy has broken down, only once there is partition, do we even start having these conversations. Okay, that's why during co-tenancy, no right for reimbursement. But upon partition, there is credit given to the repairer, to the repairing co-tenant. Oh gosh. Okay. So that is repairs. What about improvements? So let's say A installs a swimming pool for $3,000. The question here is, can A sue to force B and C to pay for the swimming pool? At first, you might have a sort of gut reaction. Of course not. A chose to put in a swimming pool, and why should B and C have to pay for it? But before you go all the way into that sort of mindset, keep in mind that as co-tenants, at least in the absence of an agreement otherwise, B and C are entitled to be able to use that swimming pool. So A bought it, A installed it, but B can come and jump in whenever they want. That's how co-tenancy works. So the question then becomes, do B and C, are they forced to pay for their share of the swimming pool? Answer is similar to repairs, but a little bit different. Okay. So A cannot sue B and C for contribution for the costs of the improvement during co-tenancy. So in that way, it's very much like repairs. During co-tenancy, there is no ability for the improving co-tenant to get anything, just like there's no ability for a repairing co-tenant to get anything. Again, absent some sort of agreement. However, just as with the repairs, the improving co-tenant does receive something when there is a partition. In this instance, though, it's not credit for costs incurred where you would need a receipt that showed how much you spent, but rather you get the value of the partition, the value difference the value of the improvement, the value difference that the improvement made to the property. Okay, so let's see what that looks like in practice. If the property was valued at $75,000 before and $82,000 after the pool was put in, therefore the value of the improvement was $7,000. So note that that's a good investment, right? A has spent $3,000 to improve the property value by $7,000. Okay. You may be thinking, well, there's probably a lot of other things that are changing the value of the property besides just this pool. And agreed. Okay. For now, I want y'all to just take my word that this is the only thing, right? That the pool caused the full $7,000. Okay. The way that value upon partition works is it doesn't matter how much the pool cost. All that matters is this number. How much value did the improvement add? So in this example, let's say the partition sale is $82,000. A, the improving co-tenant who undertook the entirety of the costs, gets the entirety of the value that the pool added. So they get $7,000, then the remaining $75,000 is split so that you get this distribution upon a partition sale. I don't want y'all to worry too much about this math. I just sometimes it helps to sort of demonstrate how this stuff works. Okay. In that example, the pool was a good investment. It's possible that the pool is a bad investment. Let's say that the pool is just heinous and somehow devalues the property by $5,000. In this example, the partition sale is going to get you $70,000 because that's the value of the property. And here, again, this one's a little harder to articulate, but this is how it works. I think the end result makes sense. A is penalized for costing the property $5,000 in value, and they take the entirety of that penalty. So it's as though here they take all of the upside risk, but here they bear all of the downside risk as well. So the improving co-tenant takes the upside and the downside risk of doing an improvement. And so here they would get less than B and C because their improvement had cost the property $5,000. Again, it's really hard to prove these numbers. Okay, and the causation, that the value of the improvement was whatever. That's why it's always better to have some sort of agreement, so you don't have to fall into this default rule. And then one last point. What if it's an improvement and a partition in kind? Generally speaking, what we try to do is give the improvement to the improver. So divide the property in such a way that the pool will go onto A's share. Okay, but that's not always feasible. So if necessary, again, OLT will be used to account for the increase or decrease in value due to the improvement. So if it's a decrease, then the improver has to pay the others. If it's an increase, then the others have to pay the improver. Okay. And I told the other group, but I'll tell you guys too, these slides that we went through today, I will post and have them available for you on Twin. We good? We done? Hopefully I'll see some of you at 2 for a afternoon hangout. Otherwise, I'll see you guys on Monday.
Can I ask just kind of a silly question?
Sure.
So when you
Can I give you a silly answer?
Absolutely, feel free. It's the end of the semester at this point. I'm not going to know the difference probably. My brain's so fried. If you are looking at repairs and improvements, you gave the example of the, like the roof, for example. If the co-tenant decides, oh, I could replace this roof for $10,000, but I want a 10 roof, so I'm going to pay $18,000 instead. Can you then aggregate those claims? Can you say yes?
Yeah, so what you do is you'll have to, just like with the accounting action, you might have to separate out like the profit from labor versus the profit from the land. So too in this space, you might have to separate out what portion of it was an improvement and what portion was a repair.
Right.
And then you'll apply the different rules to those different, to the different things.
Okay, cool. Thank you.
Mm-hmm.
So I have 2 questions.
I think Diana was talking first. Are you?
Yeah. So I had a question about like meeting with you for like exam review, mainly like individually. So I was wondering like if you had like a cutoff date for like meeting with you, because I know that like one of our professors is very like strict. He said like after next week he's like not meeting.
Yeah.
So like like for meeting with you, like do you have like, obviously I'm not gonna like try to meet with you on Thanksgiving or like a holiday or something, but what is your like cutoff date?
So the big picture answer is I don't have a cutoff date. But you're pointing out, and I think it's fair that it's not like I'm not like sort of endlessly available between now and the exam. So I might put additional slots up on the Twin link for appointments. So that would be obvious times that I'm available. But if those times don't work, just shoot me an email and we'll find a time next week that will work. But my exam is the first one, I think. And so you won't want to meet with me after that.
Yeah, and I was wondering, like I'm getting close to like finishing up my outline, and if it's like okay to like, have you like look at certain parts of my outline, or if that's not okay for the exam.
Yeah, as long as it's something specific, I don't want to just say, hey, how's my outline look? But if it's like, hey, I'm just not sure about this encroachment, actual knowledge exception in adverse possession. Can you check that out? You know, so yeah, as long as it's something specific, then I think that's fine.
Okay, thank you.
So, got two questions. First is, it's both of them about Schwartzbach. First is the, so when the husband transferred his possessory rights to the lessee, was that considered breaking the joint tenancy to become tenancy common?
No.
Okay, so so is joint tenancy only broken when the transfer is actually a full transfer, not just a you can use my rights?
Yes.
Okay, that does clear that up. Second is just, it's just something I missed when during the discussion. There was discussion, like I understand how she could have been ousted if she tried to go on the leased property, and they said no, get out. But there was discussion of her ousting the renter or her husband from it. And I was wondering, how is that? There was so much discussion of that I just couldn't figure out how like that could have happened.
Yeah, if she just came and put a fence around the property and said you can't come on, right? So when he shows up with the, you know, with the bulldozers to build the boxing pavilion, if she just stops him,
Chains herself up to a tree and says, you know,
Right.
you have to
Right.
go through me if
or
you want.
more likely, you know, put some sort of barrier in place to prevent his access, right? It's a little harder to imagine out in a walnut grove, but it's the same thing as in Spiller and Macrith. If you lock the warehouse and don't give the person the key,
Yeah.
you know, it's that same kind of thing.
I mean, I know with this case, a big part of it was that she was bedridden during a bunch of the proceedings here. So I feel like by the time she was up, that was a little bit late. But okay, that clarifies that, because I was following along with it. I was just like, where all this would she be paying rent to not have use to the property? So that, okay, that's all I got.
Okay.
Thank you.
Great.
Professor, I just had a quick question. Why would this not be a tenancy by entirety since they were married? I know we haven't gone into that, but is it because certain jurisdictions don't recognize it?
That's part of it. Even the jurisdictions that do recognize it, it has to be explicit. So because a tenancy by the entirety is a little more, I don't know if tedious is the right word. It's just a little more, it's a little harder to do anything with the property because you really have to have, I mean, the main difference is they have what's called joint management of the property, which means that not only can you not bind the other interest holder, you actually can't do anything without their permission. And so that's not good for use of property generally, although a lot of times it doesn't matter because they're marital unit and should be on the same page. But so because of that, courts require that it be explicitly created. So unless it is explicitly created, even a conveyance to two spouses does not create automatically a tenancy by the entirety. And also what you said first, which is some jurisdictions don't have tenancy.
Okay, so then it'd just be like the joint tenancy. It wouldn't be a tenancy in common, it would be the joint. Because I read they have a lot of similarities.
Very similar to a joint tenancy. The main
Yeah.
difference is that management rights.
Okay, thank you.
You're welcome.
I had a quick question. So for these default rules, does time matter at all?
Yeah. So like you're saying, if you do a repair in 2010, but the partition happens in 2020, technically no. You keep your receipts and you'll get the credit when the partition occurs. It's harder with improvements because like there's so many other things that might change the value of the property as time goes on that it becomes increasingly difficult to prove, like oh, it was the pool that made the value go up or something like that. But the technical answer to your question is it does not matter.
Okay, so how about like necessary repairs? If they just did like the bare minimum just to repair the place and 20 years pass and it's kind of like the roof needs to be replaced again.
Mhm.
Like, does that even matter? Like,
No, because during those 20 years, if the roof was working, then any of the co-tenants could be enjoying that roof, and therefore any of the co-tenants should have paid, to have the roof work during that time.
so
Does that
just
make
like,
sense?
yeah, so it's just like, hey, remember that time I fixed the roof? Okay. Okay,
Mhm.
that's all. Thank you.
But that exactly the time thing is another reason why you should agree upon it up front. Like A should call in the examples that we had, A should be calling B and C and saying, hey, I got to fix the roof. How are we going to deal with this? And then they come to some sort of agreement rather than falling into the default, because the default is really kind of unpredictable. And like you said, as time passes, it becomes, it almost feels petty. And yeah.
Thank you.
Okay. See ya.
See you.